So now, the next question you have to ask yourself, and this is a policy between you and your firm, is, are you going to accept a referral fee? There are some attorneys who choose, for whatever reason, not to take on a referral fee. That's their firm policy. And they say, we're doing a good service for our client. We want them to know we're helping them by sending them to somebody who can do this. Good luck to you. Keep us in the loop. Terrific. But we need to know that at the beginning. Why? Because if you choose to accept the referral fee, the law says you are now assuming joint responsibility for the client. Actually, the law says even if you refer the client out, you are assuming joint responsibility. So your name, the referring attorney's name is on that retainer, and it says on there, you assume joint responsibility. Now, in order to generate that referral fee, or to qualify for it, I should say, you are supposed to do some level of legal work to justify that fee. But if you ask 10 different law firms or 10 different attorneys what some level of legal work means, you will get 10 different answers. Some law firms will tell you that you need to get medical records, and that's sufficient. Some will tell you you need to talk to the client and get more details about what happened. Some will tell you we want you in on the loop and on correspondence and emails with the client to keep you abreast of what's happening in order to justify a legal fee. There are others still who turn around and say, just send us the client. We'll take care of it. Okay? Regardless of what arrangement the firm expects of you, you need to have that understanding in writing before you send the client out. So any agreement you have with any law firm, make sure you get it in writing, okay? Because you don't want to be in a situation where 3 years down the road the case settles, and now if you were expecting an attorney's fee and there's no arrangement, you don't want to be in a situation where the attorney says, what are you talking about? You didn't tell me you wanted an attorney's fee. On the other hand, if you do, just tell us. It's fine, all right? So keep that in mind as you go ahead and are now making the decision about what to do. Another thing you need to know, if you have taken the time to talk to this person who tells you their tale of woe, and you now believe that they do not have a valid basis for a case, okay? You've come to the conclusion either that their case is not timely, or that there's no wrongdoing, or there's no causation, there's no link between the wrongdoing and the injury. Guess what? You will politely tell them, I'm sorry, Mrs. Jones, I can't help you. But you have to do one more thing. And the one more thing is you must send them a letter declining representation. I call it a rejection letter. And in that rejection letter, you must send it out a certain way. You have to send them a letter by regular mail. And you have to send them a letter by certified mail, return receipt requested, because you want to make sure that they've gotten that letter saying you are not going to help them and cannot help them. But there's one other thing you have to include in that letter. I want you to reach out to another attorney immediately to get another opinion. Why do we tell you to put that in there? Because you don't want to give the client the impression that you are the be-all and end-all to everything related to law. This person trusts you. You are the lawyer. They don't know that you may handle a different type of law, so they expect that you know every type of law. And you must tell them, please, talk to another attorney. Because what will happen if you don't put that in there? A couple of years down the road, you'll get sued. And why will you get sued? Because the client says, hey, I was talking to another attorney who told me I had a valid basis for a case. And you turned around and told me I didn't. And now it's too late for me to bring a case. And you said, wait a second, I told you to go to an attorney. No, you sent me this letter, there's nothing in here. The moment you say, seek out another attorney's opinion, you're off the hook. You're good to go. You know the client got it. Send out regular mail, certified mail, return receipt requested, and you have now protected yourself. So what have you learned during the course of this morning's journey about medical malpractice? Hopefully you've learned something about the time limit in which an injured patient has to bring a lawsuit. Hopefully you've learned about why the judgment call defense is not always appropriate and does not always work. Hopefully you've now learned the 4 questions about the key questions you need to ask any injured patient the moment they start telling you about a problem that they had with a doctor or a hospital. And as you begin to talk to them and get more details, you need to know one other thing. If you choose to accept a case, you need to know what the fee is. Remember I was telling you about the fee, if you're going to accept the fee? In an accident case, the attorney's fee is a third, right? Okay, in malpractice, it's nowhere near a third. It's a sliding scale. And in medical malpractice cases, the attorney's fee after expenses start only at 30%. And they drop by 5% as we get more and more money for the client. So let's say we get 20% attorney's fee on a particular case. And you have referred the case to us, and now you would like a referral fee. So what is your fee? Traditionally, attorneys will tell you you will get a sliding scale of a sliding scale, which means if we are able to get 20%, you will get 20% of our 20%. If we can get only 18%, you get 18% of our 18%. Okay? So there's a lot more involved in a malpractice case, many more expenses and resources that are involved, and that's what you will typically find with most law firms where someone brings in a case because now you are referring it out to an attorney who handles these malpractice cases. So again, just keep that in mind. What have you learned in today's discussion? Hopefully you've learned that when somebody tells you their tale of woe, don't turn around and say, tell me what happened, because that will keep you there for over an hour. Instead, ask them, when did this happen? What's the next one? Where did this happen? What injuries did you suffer because of whatever was done wrong? And has any doctor confirmed your belief that something was done wrong? So I hope you found this information helpful. I know you're going to use it during the course of your career, if not immediately. And as you learn this information and as you talk to people, just keep this in the back of your mind. And if you have questions at the end, reach out to me. I'm happy to talk to you. I'm Gerry Oginski. Thanks everybody for coming.